Hello, everyone, and welcome to SCORE Fairfield County's webinar on Introduction to Patents and Intellectual Property. I'm Peter Talion, the webinar coordinator and a business mentor here at SCORE Fairfield County, and I'll be your host. Our speaker today is Dr. Harvey Hoffman. More on our speaker in just a minute. First, some brief information on SCORE. SCORE is a national organization with 10,000 volunteers spread among 230 offices. SCORE is a small business administration resource partner. In Fairfield County, SCORE has 100 volunteers with a wide range of industry, process, and subject matter expertise. We offer 3 primary value-added services to small business owners: free one-on-one counseling, in-person educational workshops and live webinars, about 100 per year, and extensive resources on our website, including a network of subject matter experts at your disposal. Some useful information about today's event. If you have a question, please use the Q&A function at the bottom of the screen. We will take questions at the end. Our workshop will end at 1 p.m. to respect your time. The session is being recorded, and the link to the recording will be available at fairfieldcounty.score.org within the next couple of days. Now our speaker. While in industry, Dr. Harvey Hoffman held positions ranging from research and development engineer, group manager, project manager, to general manager. In aerospace, he worked on the Space Shuttle and the Titan rocket. He holds a patent for a digital scan converter employing an accelerated scan. Dr. Hoffman is the author of project management and capstone project books and more than 20 academic and technical papers. He teaches engineering management courses at Fairfield University. He recently retired as Associate Dean of the School of Engineering and Computing at Fairfield University. It's now my great pleasure to turn it over to Harvey. Harvey, it's all yours.
Thank you very much. If you could move. So there's a great deal of information that I want to discuss this afternoon. If you want a copy of this slide presentation, what I would like you to do is take my email address down. It's right over there, harveyfhoffman@yahoo.com, and send me an email that has your name on it, and I will be happy to send you a PDF version of this presentation. You should also know that I am not a patent attorney and that I am not a lawyer. So there is no, if you have an issue with patents or trademarks or copyrights, at some point you may want to discuss this with an appropriate attorney. If we can go on now to the next slide. So we're going to be talking about the following. We're talking about patents, copyrights, trademarks, perhaps a registered design, and trade secrets. We'll talk about all of these different things. I'm not going to go deeply into this slide, but understand that this slide, patents are basically for new inventions. Copyright is for creative material. Trademarks are really for identifying a product or service. And trade secrets, well, that you keep in a vault. Next slide. Okay, it all starts, believe it or not, with the U.S. Constitution. Article 1, Section 8 says that the Congress has the power to promote science, the progress of science and useful arts. So they empower the Congress to set up some kind of protection system. And so that's where copyrights and patents stem from. Next slide, please. So let's talk about copyrights initially. We'll talk about what kind of protection it affords, who can obtain it, what can be covered, what rights are granted to you, and how long does it last? Next slide. So a copyright is really a discussion or a protection of original authorship. You can, if we go to the next slide, we can copyright a whole host of things. Things like literary works, music is absolutely legitimate to copyright. Any play, pictures, graphics, recordings, and all of this material, even website material, all of this can be copyrighted. Next slide, please. Okay. If you hold a copyright, you have the exclusive use to reproduce it, to distribute copies, to publicly perform it, and to display it in public. So you have that right. Next slide. Okay. What about an international copyright? Really, the copyrights that I've been talking about have to do solely with the United States. Is there such a thing as an international copyright? Well, the answer to that is maybe. If the United States has an agreement with another country, then there may be protection. But it's really dependent upon the laws of that other country. So you may or may not be protected with respect to an international copyright. You're protected in the United States. Next slide. Okay. How long? How long can you have a copyright? Well, basically, if it's an individual, it's life plus 70 years. So the person's life plus an additional 70 years. For a corporation, it's going to be either 95 years or 120 years from the date of creation of that particular material. Interestingly enough, you don't have to file a form with the government to copyright something. But there are times when it's appropriate to copyright something and formally. So I will talk a little bit about that. Next slide. Okay. If you would like to copyright something officially, there's a place, and this is the place right over here. You can get a copyright from the federal government. And in a moment, I'll tell you why you might want to consider that, but you don't have to. Anything that you put down on a piece of paper, this presentation technically is copyrighted. Next slide. Okay. If I want, the reason I might want to officially copyright something with the federal government and have a certificate of registration is that if somebody copies your work, then you want to be able to sue them. And unless your work is registered with the Copyright Office, you can't sue them. So that's the real reason for doing a copyright. And so you could register it, and then you could sue and possibly obtain damages and attorney's fees. Okay, next slide. Okay, copyright will not protect ideas, procedures, processes, concepts, or discoveries, especially inventions. You would want to then go ahead and patent an invention. Next slide. Okay. If you work for a company and try to copyright something, technically, the employer is the owner of the copyright. But if you are an independent contractor, you're just an individual, then you own the copyright rights to the piece. Okay, next slide. Okay, so again, you don't have to file an official registration. If you want to do something, you can follow the format that I've just shown you in this slide to copyright something, but unless you register it with the federal government, it doesn't count. But this tells people, hey, you've already done it, but you don't technically need this to copyright something. Next slide. Okay. Can you protect software? Well, you can protect some source code. You might be able to have some protection in that area. Can you patent software? Well, perhaps we'll talk a little bit about that later. So you can protect some software, but not all. Okay, next slide. Okay, so keep in mind that you can protect material, but I can quote some of your material or some copyrighted material for purposes such as criticism, if this is an article, if I'm reviewing something, news reporting, teaching. I frequently will go ahead and take some material and discuss it from a teaching perspective. That would not be an infringement if I took some material and used it in a class. Okay, next slide. So I want to jump from copyright to trademarks. And a trademark is a distinctive sign, some logo, perhaps colors, some form about your particular product. The value of a trademark, it identifies your product or service and your business name, and people will recognize that particular product or service. Next slide. Okay, so it identifies the source of the good. It does protect has some legal protection, provides some legal protection, and it helps people understand which product. Do you want Pepsi or do you want Coke? Those are trademarks. Next slide. These are typical trademarks that you see all the time. Okay. Notice in the golden arches over there, you don't even need words. Target has a recognized symbol. McDonald's has a recognized symbol. And of course, Google and all of these people, all of these are trademarks. What permits me to use this in this slide is that this is an educational situation. And for educational purposes, I can go ahead and use it. But normally I could not take this trademark in other situations. Next slide. Okay. A trademark doesn't permit you to own a particular word or phrase. You can use it. It may have some colors. It may have some shape. That's yours. And it stops others from using it. But it doesn't mean you can stop them from saying the word Pepsi or Coke or another trademark, people can use that phrase. And if they say that, if I say the word Coke or Pepsi, I don't owe Coke or Pepsi any money. Next slide. Okay. So as we will begin to see, anytime you get involved with the federal government, it takes time to get stuff approved. So I can apply for protection of a trademark, but it's going to take, goodness gracious, 12 to 18 months, roughly speaking. You'll see that in a few minutes about patents. It will take a long time for also. Okay, a trademark is typically valid for 10 years, but then you can renew it and you can continue to use the trademark and you renew it every 10 years. And you, as long as you renew it, it's yours. That trademark is yours. So Coca-Cola and Pepsi have been around for more than 10 years, but they continue to renew it and no one can touch that trademark. Next slide. So I'm going to go on to patents. Patent is a form of intellectual property. And as I've indicated, intellectual property consists of patents, copyrights, trademarks, trade secrets. We'll talk about the remainder of these now. Next slide. So a patent is protection by the government, by the federal government, for an invention, and it's good for 20 years. Now, very, very important. Keep in mind that once I seek a patent, I have disclosed my invention, my idea to the public. Okay, that's very important. The patent that I file with the federal government is good for the United States and the United States only. Okay, if I want to file a patent in other places, I'll talk about that in a few minutes, but you can just bring money. Okay, next slide. So I'm going to discuss this in some detail a little bit later, but what a patent does, it gives you ownership of a particular idea, a little invention, and you can sell that at some point. You can stop somebody from making whatever it is you've patented. If somebody imports the device or idea that you have, your invention, you can stop it in the United States, assuming that the patent is granted in the United States. You can also sell the rights for this idea, for this patent. It's good for 20 years. And at the bottom of this slide is something that I'm going to talk about a little bit later, which is really weird, maybe, but I'll show you what I'm talking about in a few minutes. The patent that you receive does not mean that you can use this invention. Yeah, listen to that. You may not be able to use this invention even though you have the patent. And I'll talk more about that. I'll clarify what I just said in a few minutes. Next slide. Okay. So when you're seeking a patent, be very, very careful. You can't sell, if you have a product, you can't sell the product. If you have a product and you have some information about it, be very careful. There is an exception to what I'm about to say, but you should not publicize. You should not release articles or give information out about this item, because it then becomes part of the public. You should not give a lecture or discuss this with another company without something called a non-disclosure agreement. Okay, that's typically called an NDA. What you should do is get professional advice. If you have an idea that you want to consider filing for a patent, probably you should get some professional advice from a patent attorney. Okay, next slide. Okay. I said there was an exception. I can talk about this idea at a, excuse me, at a conference. I can make public disclosure. In the United States, I have 1 year from the moment I disclose information about this idea. I have 1 year to file a patent application. If I don't file the patent application within 1 year after talking about this in a public environment, then I lose it. I lose the right to patent. So one has to be very, very careful about discussing or publicizing an idea for an invention. In certain countries around the world, you have less than, you may have anywhere from 6 to 12 months. In some places, you'll have nothing. So the amount of time to the publication for publication purposes varies depending upon what country you're in. The United States, you have 1 year. Next slide. Okay, there are 3 types of patents. There's the utility patent, which is probably the patent most people think about. For a process, a machine, a new improvement. This is the typical patent on a product, on an invention. Then there are design patents, which really reference ornamental type things for an article. This type of patent protects appearance. And then there are plant patents for a variety of plants that one might have. So utility patents, design patents, and plant patents, those are the patents that are available to you. Next slide. Okay, and this is some additional discussion about the utility patent or the different types of patents, and I'm not going to go into that. So next slide. Okay, so the utility patent, the one that most people think about as a patent, is good for 20 years. When the patent comes off, when the patent expires, anybody can manufacture, can produce the product that you're talking about. So you'll see drugs, their company, Abbott or Merck or one of those, Johnson & Johnson will come up with a drug, and they'll have protection for that drug for 20 years, but thereafter it can become a generic drug. Then you have design patents, which are only good for 14 years, and then plant patents, which are good for 20 years. Okay, next slide. Okay, why would you patent? Oh, I hope you may hear my dog in the background. Why would you patent something? Well, one of the reasons you patent something is, hey, ego. I did it, and I was first. Um, Perhaps another reason, and I apologize for my dog. Unfortunately, I can't stop him. Um, there's an incentive. Perhaps you want to manufacture something. I'm just going to shut my door. Okay. Or a company may want to go ahead and protect, recoup their investment if they've spent a lot of money on R&D. So they patent something and they feel, hey, they're going to recover that money. By patenting something, you have perhaps may have a commercial advantage over your competitors. For sure, one company can sue another company over a possible patent infringement. And big companies do that all the time. They sue one another for patent infringement. And also, if you have a patent, you might be able to sell it. So those are reasons why you might want to patent something. Next slide. Okay, if you're going to patent something, it's got to be useful. Okay. Of course, the question is, what's useful? And that's going to be an issue. The patent people will be looking at, is it novel? Is it different from prior material? You know, these are two statements. Is it useful or is it novel? That's going to be difficult to prove. Finally, it's got to be non-obvious. Hey, non-obvious to who? So what can be patented? Useful, novel, non-obvious, but these are very subjective statements. And it's difficult to identify what's useful, what's novel, what's non-obvious. Next slide. You cannot patent an algorithm, some kind of a mathematical concept. You can't patent a theory, a law of nature. Most computer programs can't be patented. Medical and surgical treatments, these things cannot be patented. You can't patent the human body. Okay, these things cannot be patented. Next slide. Okay, now here, look at this. When can I not, or when should I not patent something? Well, if I've already made a public announcement about this product, I can, under many circumstances, you may not be able to patent something. On the other hand, if Coca-Cola or Pepsi, they are not going to patent the secret formula to Coca-Cola, because that means after 20 years, it would be within the public domain. And they would no longer have control over the formula. So that is secret information that they want to, proprietary information that they want to keep in a safe in the Coca-Cola headquarters. And so they would not patent that. And then, of course, for many people, cost is an issue. Hey, it ain't cheap. And you'll see that in a few minutes. So these are reasons perhaps not to patent something, and we'll I'll continue. Next slide. Okay. So something that's very, very important. If I do patent something, it prevents others from making it, from using the device unless I sell it to them, that no one else can sell it. If I patent in the United States, the patent is only good for the United States. It doesn't prevent somebody from China to take the patent and build it over there. But something that's also interesting, and I'll talk about this in a moment, it doesn't necessarily give the owner the right to use his or her own patent. I'll talk about that and I'll give you an example in a moment. The other thing you should understand is the US government doesn't enforce patents. So if you have a patent on something and you work here or you live in Connecticut and somebody in New Mexico builds your device, okay, you have to somehow learn about that. And then you would then have to sue them to stop them from making the device that infringes on your patent. So the US government doesn't enforce a patent. The individual or the individual company enforces a patent. Next slide. Okay. Here's an example. We have two people who patented something. Dick patented the pencil. Jane patented an eraser. Question: who can manufacture the pencil with the eraser? The answer is neither Dick nor Jane can manufacture the pencil with the eraser because they would be then infringing on one another's patent. So just because you patented an eraser doesn't mean that you can make it on a pencil. You can make the eraser, but you can't put it on a pencil because there are two patents involved. So the two people would have to get together and arrange for something. Okay, so just because you have a patent doesn't mean you can use it all the time. Interesting idea. Next. Okay, so if you infringe on somebody else's patent, what can happen is that they can remove your products from the market. It may cost you money. You may have to pay damages to the patent owner. You may get a fine or worse. So basically, it comes down to money. It may cost you a lot of money if you infringe on somebody else's patent. Next slide. Okay, basically now, if I have an idea, it used to be when this patent system originally started that it was the patent would go to the person who could show that they were the first to invent the idea. But right now, it's the first to file. Whether you invented it or not, it's not important first. It's the first person to file. Yes, so one has to be a little bit careful. Okay, next slide. Okay, so the parts of a patent are, as shown here, you have an abstract, you have a background of the invention, a summary, figures, a detailed description or specification, and then what are your claims? What are the boundaries of your protection? So these are the basic parts of a patent. Okay, next slide. Now, this is very, very important. There's also something called a provisional patent. This is different from a utility patent. A provisional patent says, hey, I'm going to get something into the system. And technically, you can do this by yourself. You don't need a patent attorney. You can technically go ahead and provide a provisional patent by yourself. It's a simplified version of a patent. And once I file for a provisional patent, it's good for 1 year. Okay, it's good for 1 year. So, but at the end, by the end of that year, I have to file a normal patent. Okay, so there's a simple form to file a provisional patent. I can do that, but it disappears in 1 year. Okay, it does not mature into an actual patent. Next slide. So in the patent, a patent claim should define the product, how the system is structured, what are the specifics about this, how the parts interconnect, how they interact. You have to be very, very careful. Why is your system, why is your invention special? How does it differ from prior art? Okay, so and that's the material that would normally go into a claim. Next slide. Now, in a provisional patent, you don't necessarily need all the claims. You might want to include them, but you don't need them. But you do need for a provisional patent. Remember, the provisional patent is only good for 1 year. You need a specification, drawings, then you have to pay some money, and a cover sheet. And next slide. So this is what it looks like. If you send me, there is a place, there's a website, you can get this, download this, and this is the provisional patent application. Relatively straightforward, and an individual could do this without a lawyer. Next slide. Okay. If I do have a specification, if I have a specification, this is part of the provisional patent, and it should this item shows you what the specification should consist of. Drawings, very, very important, a summary of the invention, a description of the invention, how it would be used, and examples of how it might be used. Next slide. Okay, and then you might want to include, it's not mandatory, but you might want to include your claims, and then you do need an abstract. Next slide. Okay, remember I told you that the patent that you've come up with is only good in the United States. Can I broaden this? Well, technically, an international patent doesn't exist. But a bunch of countries have come together and they have a patent cooperation treaty. So technically, you can go ahead and file, after you file in the United States, you should file in the United States, you can file for all over the world. Again, just bring money. Next slide. These are all countries that participate in this patent cooperation treaty. 158 countries. Next slide. Okay, what you're going to be doing when you file for the international patent is you're going to go to Switzerland, basically, and you're going to file a patent with them or file the system with them. The picture on the bottom shows it's going to take a while. It may take on the order of 2.5 years before this is going to be accepted, assuming it is accepted. Next slide. So you might want to consider filing a provisional patent, which you can do, you might be able to do yourself, okay? And then either going to a non-provisional patent within that year, or you could also go to worldwide, file in the United States, and then go to the Patent Cooperation Treaty and maybe try to file all over the world. What's most important is the United States, and then you can then consider the Patent Cooperation Treaty and going all over the world. But clearly, it's going to take 2.5 years to do that. Next slide. I mentioned this briefly before, that not all software is patentable. Economic theories, ways of doing business, mathematical techniques, certain computer programs, these are not patentable. There are approximately 16,000 software-related patents every year. Software must be new, useful, non-obvious, same thing as a regular patent. Next slide. Okay, computer-aided software is a possibility to patent. Debugging systems, operating systems, e-commerce approaches, compilers, insurance and financial software systems. These software, the software that you see here, yes, that may well be patentable. Next slide. So you're going to probably want to work with a patent attorney. And one way you save a little bit of money is you're going to have to dig in to what the state of the art is. Help your patent attorney understand your invention and the differences between your invention and what the state of the art is and what's prior art. You're going to have to do some research, and that's going to be important. What parts of the structure of the invention can be changed without affecting the invention? Next slide. Okay. You have to show the attorney what the key structural features that produce the result of this invention. Next slide. Okay. So I'm going to talk a little bit about timeline here. A typical timeline, well, a provisional patent can be done in a few months. It might cost you with a lawyer or an attorney $10,000 or thereabouts. International patent will probably cost you a little bit more, like 15 to 30,000. And you have to understand, and I'll show you in the next slide, the first time you submit a patent, you must anticipate that they're going to send it back to you. They may indeed send it back to you. So it may take as many as 3 to 5 or 6 years to get something patented. Might. So one has to be prepared for that. Next slide. Okay. Keep in mind that a patent attorney is not cheap. A patent attorney might charge something on the order of $500 an hour. Could be that much. You know, a simple concept of a patent, like a switch, a paper clip, diapers, that kind of an idea, something simple, could be as inexpensive as $5,000 to $7,000. But when you get up to more complex systems to patent, you have to anticipate some serious money. And it might cost a person anywhere from $15,000 to $50,000 to patent something. So it could be as simple as $5,000 if you go with a lawyer, or as much as, you don't know, $50,000. Next slide. So when you're doing this, you want to determine what type of intellectual property protection do you need? Do you think your invention is patentable? What kind of patent do you need? Went over the 3 patents. Get ready to apply. You will submit your initial application. Okay. You're going to have to work with the examiner in Washington. And there may be some back and forth on that. And you receive your approval, and then you have to maintain your patent, and that costs a little bit of money as well. Next slide. So I took this down from the patent office, from their dashboard. Do you notice that over the years, I submit a patent or a request for a patent, and the first time they get back to me, the patent office gets back to me, well, it can vary from a year and a half to where it is now, it's about 22, 24 months. So it could, just the time between the first time submitting a patent and the first time the patent office gets back to you saying that everything is wonderful, or you got to make some changes, the first time they get back to you could be as much as 2 years. So this hasn't happened overnight. Next slide. Okay. I'm going to skip this slide. It's saying it's going to, the average patent might take between 2 and 5 years. Next slide. Okay. Now, I'm bald now, but at one point in my life, I had hair. And let's just imagine that because of my hair, it was falling into the drain. So I imagined that I came up with an idea for a hair removal device to place in a shower drain. So what I want to do, I'm going to give you a research example on how to look up a patent. I've given you the website there, and you're going to be doing a basic or advanced search to see if you can come up with a hair removal device. I have an idea. Has anybody else come up with this device? Next slide. Okay, this is the website for the patent office. And you notice there's a basic search and an advanced search. So I can press on either one of those. Next slide. Okay, this is what the basic search looks like. This is what it looks like, and you would fill this in. I'm going to go to the next slide and do an advanced search. I'm going to do an advanced search. Oh, this is what the advanced search looks like, but next slide. I filled out, oops. No, okay, next slide. Next slide. I don't know, I'm missing something. Oh, okay. On the top over here, are all the things, it's very difficult to see on this. I put sink, shower, drain, hair, and it's a collector. I put all of the key words. Because I want to see if somebody else came up with a patent. Next slide. Did somebody else come up with something? And notice there are a bunch of people. It looked up those special words and it came up with a bunch of patents that use those special words. Next slide. So on this, I discovered one that may be, it's called a sink, drain, and hair collector. It's on the right-hand side. I want to find out more about this particular device. So next slide, I press on the T, and here is a copy of the patent. So I would have to read this to see if this patent, if this idea is similar to my idea. And I would have to do this for, I don't know how many patents that are in the system to compare this idea with my idea to see if I'm infringing on this patent. Next slide. Okay. These are the basic fees that you might confront if you are, depending upon the size of the company, of the corporation, you might go from a small fee to a larger fee, and you can see that right over here. It's not hugely expensive for the government. These are government fees. Next slide. How does artificial intelligence creep into this? Well, with respect to artificial intelligence, it may or may not. If I come up with ChatGPT coming up with something, is it patentable or is it copyrightable? It may not be, because is it the work of a human creator or not? If it's a work of a human creator, then I can't do it. So it's really difficult to say whether I can patent something that is artificial intelligence or not. Next slide. So if an AI system creates a document or an art, then the copyright may belong to the person that owns or operates the AI system. Some people, some legal scholars, believe that anything created by AI is in the public domain because it's not authored by a human. So the answer is, I don't know. You have to come up with that. Is AI copyrightable or not? I'm not sure. There are both ways. People can look at it from both perspectives. Next slide. Okay. Hey, if you want some free help, some free guidance, UConn offers it. UConn offers some free guidance, and here's a number that you can contact them, and they have some law students who might be able to help you with developing a provisional patent, say, and you can get some guidance from them at nominal or low or no cost. Next slide. My question to you is, do you really want to patent it? That's your decision. And I'll entertain some questions. Next slide. So I'll entertain questions at this point.
Thank you very much, Harvey. Let me just see if there's a questions or two in the chat.
I know I went through this very, very, very quickly. There's a lot of material, but if somebody would like a copy of this, I can send out the a PDF version of this to you if you would like it. Just send me an email. I don't want to see anything in the chat area. You send me at harveyfhoffman@yahoo.com, and I'll be happy to send you a PDF version of these slides.
All right, well, thank you very, very much, Harvey. This was an excellent presentation. This session was recorded, so you can get a replay of Harvey's speech, and then you can send him an email to get a hard copy of the presentation. Once again, we thank you very, very much, Harvey. The recording will be available on the SCORE website within the next couple of days. SCORE thanks you, Harvey, for the presentation. That brings us to a conclusion, and we wish everyone a great, great day. Thank you so much. Bye-bye.